Good morning. Are you Matthew Wadsworth?
Yes, ma'am.
And Mr. Wadsworth was previously in court and entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in prison. I've received
Food commentary. Right off the bat, we're hearing that Matthew Wadsworth cut a deal, 8 years max for aggravated assault with a deadly weapon. Now here's the kicker. With his kind of record, that's not just a bargain, that's a miracle. So ask yourself, why would the prosecution settle for that cap? Strategy, sympathy, or maybe just exhaustion from dealing with his endless rap sheet?
the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
No, Your Honor.
Not from the state.
All right, Mr. Rojas, you may proceed.
Yeah, Judge, this is a cap of 8. The agreement, I think, is a cap of 8. And just based on the criminal history alone and the PSI, it looks like
It looks like you did a very good job of getting that agreement.
that's kind of what, not that I did a good job, but I think that may be doing a favor to Mr. Wadsworth. However, Judge, there are some things I'd like to point out. If you look at, and I'm talking about his felony criminal history, the first page of his, or I guess rolling into the second page of his felony criminal history, most of those offenses happened in 2002. So he seems to be getting those in bunches. Those happened in 2002. He got sentenced in 2000, all one. In January of 2002, they all happened.
Right.
Got revoked in 2003 on all of them. I think he did 60 months on all of them.
VU commentary. 7 additional felonies after 2002? Folks, this isn't a one-time mistake. This is a pattern. And in law, judges look for patterns. It's like telling your boss you're late once because of traffic and then showing up late 7 more times. At some point, nobody's buying the excuse anymore.
Got some more in October 2002. Then after that, he goes and basically he's in and out until about 2019 when he picks up some more cases. And from 2019 to this present case, he's
From after the 2002 and to the 2019, there were 7 additional felonies.
Yes.
7 additional felonies.
yeah.
Go ahead.
And then from 2019 to now, at least, he's able to stay clean. So he tells me that most of the time when he's committing offenses is when he's off his medications. He's been back on the meds now in jail. It's helping him. He's able to think clearly now. We talked about this, and if the court's even going to consider probation, as pointed out in the PSI, the only way he's going to get probation is to say PD to help with his drug issues. And he understands that. He recognizes that. He's willing to do that. He's hoping that you give him a chance to do that. And even as he was pointed out by the probation officer in the report, he's indicated to them that he's tired of this lifestyle. He's tired of being in handcuffs. He realizes he needs help just to make his life better. And he tells me he's ready to make that change. And he does have some statements to make to you.
VU commentary. Now here's where things get complicated. Wadsworth reveals a traumatic backstory, abuse, addiction, and mental health struggles. And this is something courts wrestle with all the time. How much of someone's criminal behavior is choice, and how much is circumstance? Should trauma lighten a sentence, or does public safety always come first?
Appropriate time.
All right, go ahead, sir.
I only wrote this because I get really nervous.
Sure.
So I said, this letter is to ask you for some help. I'm a drug addict. I can hold on. Basically, listen, man. I was a bad kid until I was ADD poster child. I was put on Ritalin. Then I did really good. The Ritalin, I went from straight F's, farting in class, thinking it was funny, picking my nose and eating it, all that stuff. I thought it was, I just was bad. They put me on Ritalin. I went from straight F's to straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something. And I hope it don't hurt me, but I got beat up. I had a robbery in 1992. When I got out from that robbery until 2000, when you started, 2002, yes, ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. If I'm off of them, and the reason I got off of them and this offense happened is I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on in my head. Our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 19. I said I'm tired of this, and I'm gonna stay on my medications. When the house burned down, all my medications went with it, my truck, my tools, and everything. And I was just barely making it. And I honestly thought my roommate was holding my girlfriend against her will and hostage. And we started fighting, I was losing. And I hit him. If you do give me the chance, what I need is some help staying on my meds. Because I start feeling like I'm doing better sometimes. And then I stop taking.
Full commentary. 21 felony convictions. Let that sink in. That's not just a red flag, that's a whole parade of red flags marching through the courtroom. The judge even admits she's never seen a criminal history this bad. Viewers, if you were sitting in her chair, could you risk putting this man back on the street?
When I stop taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or I can't tell.
So, but Mr. Wadsworth, here's the thing.
Yes, ma'am.
And I appreciate what you're saying, and I feel like you are sincere in what you're saying.
Yes, ma'am.
The problem is you're 51 now, 52?
51. Ma'am.
51.
Fixing to be 52.
And you know you've had these issues.
Yes, ma'am.
You've been given opportunities, and you know I need to be on my meds. And even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. Honestly, I'm not sure, but I honestly think that you have the worst criminal history I've seen.
I even said that to Mr. Rojas. I said, "This is
You have 19 misdemeanor convictions. You have 20 others that were either filed, dismissed because of pleas on the other cases. So technically about 39 misdemeanors. 21 felony convictions. 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And out of and in addition to the 21 and the one pending, you have 16 others that were dismissed because of plea agreements and things like that. So that's 38 felonies. The last, and I get a lot of this was from '02, and a lot of it was in the same big scenario.
19 of them was in one.
But it didn't stop then. You were put back on probation in 2017, so not that long ago. Given a probation, it was revoked. So you were given an opportunity. Mr. Smith?
I've completely stayed out of trouble since then, though. Not one single incident.
Well, you had 2017 an unauthorized use of a vehicle felony. 2018 an obstruction of
VO commentary. This is wild. The judge flat out says she considered rejecting the plea deal altogether. That almost never happens. Why? Because plea bargains are the backbone of the justice system. If every case went to trial, the courts would collapse under the weight. But here the judge is basically saying, this deal feels like a joke given your record. That tells you just how extreme Wadsworth's case is.
Of justice in Pike County.
Yes, ma'am.
2019, an escape. That's the one that's
That was my
pending.
last one.
Hold on.
Oh, I'm sorry.
And then another later in 2019, maintaining a common nuisance of a controlled substance or something like that in Indiana. So the last thing is 2019, which is in the big scheme of things at your age, not that long ago.
I know, I understand.
Mr. Smith?
Judge, I would point you to his account of probation where he said the part about the baseball bat is not true. A dresser fell on something.
I saw that.
He's still not accepting responsibility.
I hit him with the cane.
Hold on, don't
I'm
speak
sorry.
over. I let you talk, so don't talk over anyone else, please.
I believe probation is absolutely right that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8 years to be sent.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement. Because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you get out to either change your life if you really want to or not, and you'll have to do that on your own. All right, good luck to you, sir. You can go back with the bailiff. Good morning, sir. Are you Dauran Keith Byerly? And Mr. Byerly has two cases that he is currently on probation for, and motions to revoke probations have been filed in each of those. Cause number 18-28800. On probation for violation of a protective order, and also in 18-29063 on probation for violation of a protective order. Those are both deferred probations. Mr. Burbank has filed requests in both of those cases asking that I set bonds. Sometimes I do that without a hearing, but due to the nature of the underlying offenses as well as the new alleged offense, I wanted to come and hear from probation and the state as to what your position is with regard to any bond that I would set. Ms. Malfino?
Yes, ma'am. Judge, obviously I will defer to whatever Ms. Johnson thinks is appropriate. I do want to let the court know I did reach out to the complainant in the underlying offense. I've actually maintained contact with her just on a friendly basis since the original offense that I handled back in 2019, just to be able to assure the court that those issues do not involve that complainant, the issues that he's having now. There is no issue with the Hartley family, which I was glad to hear. Obviously, my concern is that there's been another assaultive offense. There's also been an allegation of a possession of a controlled substance. So 2 new offenses while on this bond, in addition to multiple violations, in addition to everything that Ms. Johnson has already made available to Mr. Byerly. So I know that he's entitled to a bond as he is on deferred.
Maybe he is without certain findings. So that's why we're here. So just also for the record, Mr. Byerly, and I know you know this, but I'm going to go through just so that we're all clear what the allegations are in that motion, and just that they're allegations, and obviously they haven't been proven true. But it looks like you have an allegation that you committed an offense of assault April 21st of 2025, that you tested positive in a urine sample for opiates, that you did not provide verification of attending the JCDI program. Looks like there was another urine sample that tested positive for alcohol in April of this year. Then it also alleges that you committed a new offense of possession of a controlled substance, May of this year, that you possessed crack cocaine, which is the same date as that offense. and that you were at a other location other than your residence at approximately 3:19 a.m. on May 29th, the date of that offense of this year. So what do you have the status? I know the lab, we've had some issues with lab results. Is there any idea on that, Ms. Malfino?
I do not know, Judge. I would venture to guess that with it only being several weeks ago, we probably do not have anything. I'm happy to reach out to the agency and ask if they can expedite that through the lab and be prepared for a hearing whenever the board meets.
And Ms. Johnson, thank you for being here. And so what is your thought, I guess, with regard to setting a bond? And if I did set a bond, what specific conditions do you think would be
So
helpful?
I received his case. I became his officer in February of last year.
Okay.
And since then, I have put him in ISF cognitive. I have put him in JCDI. Prior, he's on an MRT. He tells us that he understands that he has a drug problem, but then still continues to go do what he's doing. We've tried to help him as much as we can. And I went and visited him, I believe last week or 2 weeks ago, and he told me the reason he would need a bond was so he could go work out of the county. And I don't think that's a smart decision. If you put him on bond, I would say a drug patch would be smart. A GPS would be smart, but ultimately, Your Honor, it's up to you, but I don't think a bond is a smart decision.
Yeah, I don't either.
Can I have?
You may. Go
can I
ahead.
ask her a question? When did you place him on JCDI? Do you have a date of when this time? When was he actually placed? Was it 2019 when he was placed on probation?
For probation?
Yes.
2019, May 13th.
When did you place him on JCDI? Was it just recently?
Yes, sir. It was in the last.
February of 2025.
Okay, so what changed between 2019 and February 25 to say now you need JCDI?
His drug intake went up. We've tested on multiple occasions. He's tested positive for cocaine on multiple occasions, and we believe outpatient would be the best for him. He had spoken to me briefly as well that he had some issues he wanted to talk through. He had some family issues he wanted to talk through. So we got him in front of a counselor. Him getting the drug treatment is what he needed. He agreed with us. That's what he needed. So he believes that outpatient program is the best option for him.
Did he go to JCDI?
He did. He did test positive on multiple occasions. He drank at one point, and he admitted that to us.
So when did he stop going to JCDI, or was he still going at the time of this offense?
He was still going at the time of the offense, but since he picked up a new offense, they had to drop him from that program,
So it was the new offense that dropped him, it wasn't him not going?
as well as the drug use.
And was there another program too that you said?
He had done ISF cognitive track.
What is that?
It is the interesting facility that we send people to, about 90 days long, and he went the cognitive track, so the thinking track.
And roughly when was that?
March of 2024.
Thank you.
All right, anything else, Mr. Burbank?
Mr. Barrow, you've heard what the probation officer said. Did you talk to the probation officer?
Yes, sir.
Speak up so we can hear you.
Yes, sir.
If the court was to allow bond, what is your plan in reference to what you would do when you got out?
As far as my plan, I mentioned to my probation officer, and I mentioned also to you that I would like to get into an outpatient program at that rate choice if possible, which will allow me to, I just told her I couldn't work out of the county. The reason why I asked for that was because I'm working at minimum 1,000 hours less than I'm going to work.
You are a longshoreman, is that
Yes,
correct?
yes, sir, I am a longshoreman.
And the incident in reference to the assault had to deal with your supervisor at the port, is that correct?
Yes, sir. It is.
And so the only ports that you know of are either Houston, Corpus Christi, or Louisiana that
I
you
work,
would go
I
to.
work at, and just make that, as far as making my payments and getting back on track, I had a stroke last year.
I'm not worried about your
VO. Commentary. This is where things really crash down for the second defendant, Devin Barley. Imagine being on probation, already skating on thin ice, and then getting caught in a car at 3 a.m. with drugs and paraphernalia in an area known for crime. This isn't just a bad look. It's basically the court's worst nightmare scenario. And honestly, how do you sell the judge on second chances when the evidence paints a repeat offender?
payments.
Yes, ma'am.
You had a stroke last year?
Yes, sir.
And you're still testing positive for drugs after having a stroke.
Yes, ma'am.
Okay. All right.
Issues. That's my excuse, but that's my daughter.
Do you have a place to stay?
Yes, I do.
And where is that?
Two was apartments, on Mosaic Apartments is where I
Who
live.
stays with you?
No, I live by myself.
Who would supervise you? Do you have any family?
Yes, I do have
What
family.
family do you have?
My sister, Latoya Byerly, also my mother, Byerly, and I have an uncle, Christopher Williams.
And how far away do they live?
Well, as far as my mother and my sister, they live in Houston. As far as a good friend of mine, she lives right there in Fort Arthur, in Mount Fraser.
Do you have any kids?
Yes, sir.
Where are they?
I have one in, she's a cheerleading coach at Iowa State University. My son is in, I got two kids here in Beaumont. One that I'm not allowed to see, and then also Tristan, who I just reconnected with Tristan, my 11-year-old.
Mr. Viola, just one last question.
Yes, sir.
How can you guarantee this court, if released, that you wouldn't be taking either alcohol or drugs pending the outcome of this hearing?
Well, for one,
What guarantees?
I would accept that offer of the patch. And I would guarantee, I just want to get back to work. What I do well is go to work and come home.
You do other things because you've done other things.
Yes, I have.
What's the guarantee that says you're not gonna do those other things when you're doing work and going home?
At this particular time, offer my word, even though the past doesn't.
That's right.
Yes, and that's what I told him. I see this as my last opportunity to keep everything that I have and not have to test.
One of the things is that you tested positive. What date was that, Your Honor? On the,
I don't know, Mr. Burbank. What date is it?
now I was wondering what date it was on the allegation.
There's a date of April, if I may.
Go
April
ahead.
29th, April
Did you
15th.
test positive for alcohol back on that date?
Yes, I did.
And was there a date also of positive for cocaine? Was there?
Yes.
Yeah, there was. So those allegations are true, correct? If the court is not considering a bond and that he needs help, he has pled true, Your Honor, to testing dirty at this point.
Well, he hadn't pled. We're not sworn in, or I mean, if he wants to plead to the motion, we can take care of that. With regard to the bond, the allegations, at least for that new offense on May 29th of this year, is that approximately 3 o'clock in the morning, 3:20 in the morning, you were sitting in a running vehicle in an empty parking lot in an area known for prostitution and drug use. You roll down the window to speak to officers. White smoke comes out of the vehicle. You get out. You got crack pipe, allegedly. 4 pieces of crack were found on you, allegedly. My fear is that I don't know whose car you were in, but obviously it's scary to think that you're out possibly driving in the middle of the night, either finding drugs, using drugs in the wrong area after. This is your 5th administrative hearing. So you've already been given 4 opportunities with probation without having come in front of me on an MTRP. They've gone so far above by letting you work out things administratively with ISF, with JCDI, and I approved those things, but they did those things without saying, let's revoke his